Lord, there is a delay of 51 days. Lord,
Come on, merits.
Lord, merits, my Lord. Lord, the issue is that, my Lord, I was working, my Lord, earlier as, my Lord, in United States, my Lord, I was employed as employed with a person called Ramesh Chandra Patel. Now, my Lord, there, my Lord, what happened was, my Lord, I left the job. My Lord, they filed cases against me. My Lord, a notice was issued by the court in United States against me. Now, my Lord, my case is that the service which was done upon me was against the provisions of the Hague Convention on Service, my Lord. Because, my Lord, that has to be done through a central authority.
Who are you?
Lord, I am the person against whom the case was filed in United States and notice was issued upon me.
Oh.
And, my Lord, my case is that notice, my Lord, that is issued upon me is not in accordance with the provisions of the Hague Convention, because notice was issued by the court.
Come to para 60, para 6, page 13.
Page, my Lord, para 6, my Lord, page 29.
13, 13. Affidavit in reply is filed on behalf of respondents.
Yes. Affidavit in reply is filed on behalf of respondents to the effect that the Hague Convention on Service Abroad of judicial and extrajudicial documents in civil and commercial matters is a treaty entered into for service of documents of foreign courts on persons residing in a different country. Both India and United States are signatories to the treaty in reference made under Article 2, 3, 5, 8, and 9 and 10 of the convention. It was stated in the affidavit that in view of such convention, services of the documents were made upon the petitioners. In view of the aforesaid facts, no case is made out for interference, and while exercising powers under 226 and 227 of the Constitution of India, the petition is accordingly dismissed. Notice is discharged, no order as to cause.
What documents you were served by the
Lord, notice, my Lord, processed by the court in United States, my Lord.
Sir, you should thank your stars that you were not issued with lookout notice. There is a dispute here.
Sorry, my Lord.
There is a dispute here.
Not here, my Lord, there in United States.
Then what was the summons which was issued by this court?
My Lord, by the local court, nothing is issued. Huh? By the court in United States, my Lord, a notice is issued upon me.
Then go and challenge there.
Lords, may I, my Lord, submit, my Lord, I'll take instructions.
You are an Indian citizen.
Yes,
correct? You are a OCI?
Lord, yes, my Lord, I am an Indian citizen. My Lord,
Indian citizen. All right. Overseas Indian citizen.
Yes, my Lord.
OIC.
Lord, that, my Lord, I'll have to check, but my Lord, I am a citizen of India.
So you are continue to be a citizen of India and you are residing in US.
I have, my Lord, come back to India now. I have come back to India. Lord, I am residing now in India.
Now, for some mistake or error or illegality committed, the US court has issued a summons to you.
Yes.
It is to be served.
Yes.
And the embassy officials have served you in America.
Lord, in India, my Lord, the local police has served me. That is my case.
Rightly so.
Local police did not have the authority.
Rightly so.
May I, my Lord, submit? Lordship may keep it at 2:30, my Lord. I'll take instructions and.
There is a delay of 64 days. How many
51.
51 days in filing the appeal, which in the normal course this court would have condoned. And in order to ascertain as to whether there is any substantial issue involved in the appeal which has been filed, challenging the order dated 16/12/2019 passed in SCA 13901 of 2015, we have heard Mr. Aditya Gupta,
yes,
learned counsel appearing for the petitioner on merits, and find there is no merit in the petition and it has been rightly dismissed by the learned single judge for the reasons indicated herein below. The record on hand would disclose that the summons by the Supreme Court of State of New York, County of Nassau, USA, was served upon the petitioner by local police. Hence, questioning the same, he sought for a direction or order to the respondents to quash and set aside the alleged illegal act of the respondents of service of foreign judicial documents without following the due process of law. Para, India being a signatory to the Hague Convention has entered into an agreement whereunder it is agreed for service of documents of foreign courts on persons residing in different country. Both India and the United States of America are signatories to the treaty in reference made under Article 2, 3, 5, 8, 9, and 10 of the Convention. Full stop. This fact has been reiterated by the respondents in the reply affidavit filed before the learned single judge, which has also been taken note of to reject the prayer of the petitioner. In that way of the matter, the summons stroke documents were forwarded to the district judge Rajkot for service on the petitioner, and accordingly the documents were served upon the petitioner. As such, the learned single judge has rightly refused to exercise the extraordinary jurisdiction vested under Article 226 of the Constitution of India. We see no error having been committed by the learned single judge, either in law or on facts, for entertaining this intra-court appeal, assailing the order of the learned single judge. As such, we are of the view that issuing of notice on application of condonation of delay and entertaining the appeal on merits once again would only be an exercise in futility, and as such, the appeal itself being devoid of merits, we do not propose to issue notice on application for condonation of delay. Consequently, both on the ground of delay and on merits, the appeal as well as the application stands dismissed.